A lot of people talk about asserting their rights and how they're going to sue people, etc. But do know that civil procedure law, you must be aware of the safeguards in that as well. And that's a little more complicated than criminal law or traffic law, and common law as well, because common law is rather uh, plain. It was for a reason, right? Just like the Constitution, hint, hint. But when you're dealing with civil law and you're putting in a claim, especially on a federal level, the language has to be proper and you must have a cause of action. What do I mean by a cause of action? This isn't legal advice, right? Um, you have to have a valid claim. You have to have a cause of action. You can't just say, this is what happened to me and I didn't feel right. He violated my constitutional rights. I'm suing him for this amount of money. You have to prove the amount you're seeking and how the damages meet that number, right? You have to prove your cause of action and what the true damage is in language where you are heard on the record, right? What do I mean by that? You can't say he just hurt me, assault. No, intentional infliction of emotional distress, unlawful arrest, right? Malicious prosecution, defamation of character, property damage. Those are causes of action. Then you have to expound further into that to describe how, when, and who caused that action. That's your claim. Because if not, you'll file a complaint to the federal court and it will get dismissed for being a frivolous claim, failure to state a valid claim. Another thing is when people think they're going to sue people, even if you beat a case, right? If there was probable cause for the initial arrest or claim, you don't have probable cause or cause of action to put in a claim for monetary damages because they weren't in the wrong. You might have beat it through a technicality, and through that technicality, whoever has the nexus to that, you might be able to sue in their personal, individual capacity. But in regards to the original claim, if they had probable cause, they're immune. They had no willful intent to do anything wrong. So they didn't harm your personal property. Civil laws are totally different. You have to know deposition, especially if you're a plaintiff coming with a claim. Once you get finished with discovery comes depositions. So after you decide to give their evidence, right, you have to put in your notice of deposition with your terms in it as well. It could be 100. It has to be within 100 miles of where you're domiciled. It's up to you to decide where. It's a lot, right? You can have it videotaped, etc. Right? Then you have to know how to handle yourself in said deposition. You have to know that when you're being deposed, how to object to form, cause for speculation, ask and answer, right? I have to file a complaint for sanctions because you're badgering me now. I've answered this question already, and you're continuously doing it. Object to form, right? So you have to know how to handle yourself in a deposition because a deposition is testimony before trial. It's a mini trial. It's like a trial, and you'll be asked the same questions later on in trial, and you have to know the exact same answers, or else you will open the door and they will expound on such and try to disqualify your testimony. That's how it works. Then you have to know how to give a deposition as well and ask the questions to ask without giving them your whole case, and formulate a structure that you can use in trial when you cross-examine them to say, well, based on your testimony in the deposition on such and such a date on page blah blah blah, seen here as exhibit blah blah blah, you stated, oh, you need to check, bailiff, request, can you hand this to him? Does this, after reading this document, does it refresh your memory? Okay, now based on this document and your own sworn testimony, is it not true that you that personally stated that blah 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 blah? Yes, well, you just stated on the record right now that this, that, and the third. That's a conflict. It can only be one or the other. So you have to know how to carry yourself in a deposition. You have to know how to use those transcripts you get from said depositions, and then form a structure to cross-examine at trial in conjunction with the testimony from depositions and accompanied with the evidence from the discovery. That's how it works. And then you get a decision from a trial by jury based on your cross examination and your argument or claim. And then, after if you're the plaintiff, you know, you get to speak first to the jury, and then the defense does. But at the end of the trial, the defense gets to speak first to the jury, and then you give your closing argument to sway the jury based on the evidence presented before the court. So to safeguard yourself, study civil law, because all law is based on civil law, commerce. Stay sharp.